Welcome to everyone to this webinar. My name is Pascal Pichonnat and I'm president of the European Law Institute. It is therefore my privilege, but also my great pleasure to welcome you all to this ELI webinar on the ELI model rules on impact assessment of algorithmic decision-making systems used by public administration. Yes, the title is very long, but the content of such model rules is very important too. I will not present the ELI, but do not hesitate to visit our website to discover all our various projects or to apply to become a member if you are not yet a member. 3W European Law Institute in one word.eu in that case. These ELI model rules are certainly a significant and timely contribution to the legal discussions and attempts to regulate AI in Europe. While inspired to some extent by EU law and compatible not only with existing EU law, but also with the law currently being drafted, ELI's model rules were designed so as not to be dependent on EU law, but they could serve also as an inspiration to national, including non-EU states, national and EU legislators, to governments and of course administrations. Fundamental issues of protection of fundamental rights on the one hand, and on assessing the impact of algorithmic decision-making systems on the other hand, at stake in these model rules and their 16 articles. Indeed, in the 21st century, one cannot ignore the raising impact of ADM systems used on an everyday basis in the public administration. Instead of ignoring these impacts, or on the contrary, taking a stand to prevent any use of ADM systems, these model rules take a proactive perspective to assess their impact by involving both experts and the population for some ADM and ensuring a follow-up on these issues as we will hear today. But I do not want to enter into those details myself, given that we have today an exceptional panel of speakers, reporters, team members, but also so-called third party that will also shed their views on these model rules and the current evolution in the context. They will each speak between 5 and 10 minutes. Then we will have a short Q&A session. Let me already thank the panelists for giving us the honor and the pleasure of being with us today. I'm truly looking forward to their views and ideas and to the various paths that their reflections and of course the ELI model rules will open. But before listening to them, let me give you some technical instructions. Basically, all the questions can be put by using the Q&A function that you have on your on the lower part of your screen, so that you may increase your chances to have your question pick up, if I can say so. Please do not wait until the end of the presentations. You can really ask questions when they pop up in your mind and put them on the Q&A possibilities. We will begin with a joint presentation of ELI project team members or by ELI project team members, and then we will have in a second time the external perspectives. Now for the ELI project team members presentation, we will have 4 speakers. First, Professor Jens Peter Schneider. He is a project reporter and professor of public law at Freiburg University in Germany. He served, of course, as project reporter on these projects, but also worked in research network on EU administrative law. And he worked a lot in the field of artificial intelligence, on public administration, and of course, the link of both, such as in this project. Next to him, we will have the pleasure also to listen to Jonathan Dollinger. He is a project team member, a research assistant, and a PhD candidate at the University of Freiburg. He's also a trained lawyer. He spent some time at the Regional Court of Stuttgart and at the Administrative Court of Appeal of the state of Baden-Württemberg. And he works in his PhD research on the risk management and impact assessment for digital technologies in the GDPR and the EU's draft AI regulation. Then we will also have the pleasure to listen to Karolina Wojciechowska. She's a project team member and researcher and assistant professor, attorney at law. She's assistant professor at the Department of Law and Administrative Proceedings of the Faculty of Law and Administration of the University of Warsaw. She's a qualified attorney at law and a mediator. She is also a lecturer of the training for trainee attorneys at the Warsaw Bar Association and a member of the examination commission for the examination for attorneys for the Supreme Bar Council. And finally, in this first bunch of speakers, we will have the pleasure to listen to Katarzyna Dziolkowska. She comes also from the University of Warsaw. She's a junior researcher and lecturer, a PhD candidate, and she works as a junior associate at Koszański and Partners law firm in Warsaw. Her research focuses on the digital transformation of public administrations in line with the EU laws, values, and human rights. So I think it's high time that I give the floor and the word to Jens Peter Schneider and the whole team for their initial presentation. Thank you.
Dear Pascal, thank you so much for your kind introduction. And dear audience, thank you so much for sharing your lunchtime with us and your interest in our webinar and in the output of our ELI project on AI and public administration. During the next 30 minutes or so, I and 3 other members of the project team, already introduced by our president, Pascal, of the project team, will present to you the key elements of the ELI model rules, which are the result of our work during the last 2 years since April 2020. As you can learn from the agenda, after a short introduction to our project team, the main part of our talk will give you an overview of the overall impact assessment procedure. 2 of its aspects will be especially highlighted. First, the requirements for the obligatory impact assessment report, and second, the rules on expert audit and public participation applicable in case of high-risk systems. We will end with issues which were raised in our extensive process of discussions in various fora efficiently provided by the ELI. An especially important issue since 2021 was the compatibility of our model rules with the draft AI Act as proposed by the EU Commission and discussed at the moment in the legislative bodies of the European Union. Our project team follows the established structure of ELI projects with a chair, a small number of reporters, supported by a drafting team, as well as by an advisory committee and a membership consultative committee. I'm very grateful to the ELI for selecting me as one of the 3 reporters, as well as for conveying all the other members of our drafting team and the wider project team. It was absolutely inspiring to collaborate with such excellent colleagues from academia or legal practice from all over Europe. In times of war in Europe, such constructive and trustful pan-European cooperation is a wonderful experience. How much could our continent flourish if we remind lessons of our sad European history of wars and totalitarianism? Today, our project team is represented by myself and 3 other members of the team already introduced by Pascal Bischonowitz. And they are now highlighted in light blue markups here. The 4 of us will successfully guide you through the impact assessment procedure using a graphic you might have already discovered in our report. The first slide concerns the process of designing, developing, training, and testing an AI system to be used by public authorities. Of course, this stage precedes the impact assessment procedure, but the obligations to cooperate provided in Article 7 are fundamental for a meaningful impact assessment report, especially. Another preceding stage is a screening exercise. Screening is part of our approach to define the scope of application of the impact assessment procedure. Our starting point is that we drafted our rules to cope with challenges and risks connected with new technologies covered by the term artificial intelligence. However, we discovered at an early stage that AI is not clearly defined at the moment, or even cannot be defined. In addition, other technologies of algorithmic decision-making may cause similar important risks for individuals or society than AI systems. Thus, we decided for the broader concept of algorithmic decision-making systems. But such algorithmic systems are in widespread use in our digital age. Consequently, we took, to some extent in line with the Draft AI Act, a risk-based approach. We propose at the first level that legislators put algorithmic systems into 3 boxes. The first box is our Annex 1. This contains systems using certain technologies or systems used for certain administrative tasks, which might be classified by legislative bodies as potentially so risky that they should always be subject to an impact assessment. The second box is our Annex 2, which shall list systems or use cases that do not require an impact assessment according to a general legislative evaluation. And thirdly, a system might not fall in either of the first 2 boxes or categories. Only then a screening exercise with a preliminary risk evaluation based on the questionnaire takes place in order to determine the concrete use cases, concrete use cases, whether a full impact assessment is needed. Jonathan Dollinger will now present to you the next 2 important elements of our impact assessment procedure.
Thank you. Now that we know when an impact assessment must take place, let me start explaining how the impact assessment proceeds. The impact assessment procedure opens with scoping. Just like screening, this is known from environmental impact assessment. The implementing authority determines in advance what the most important issues for an assessment of the particular system will be. It can consult the supervisory authority and independent experts to help with this task. Then the implementing authority can start to produce the impact assessment report. This report is prescribed by Article 6. Article 6 is really one of the centerpieces of the whole procedure and of our model rules. It aims to provide a structured and detailed guidance of the issues to be assessed. This also means that the article is quite long. You can see the central points of Article 6 here on this slide. In the next few minutes, I will take you through the most important components of the report step by step. But 2 notes beforehand. First, the implementing authority is really encouraged to go beyond strictly legal compliance checks here. The assessment also looks at wider societal issues which might not or not yet be regulated by law, but the report should still make such impacts transparent. Second, the issues listed in Article 6 are not strict legal standards to be met. We do not wish in this project to create additional material requirements next to fundamental rights or the GDPR or the Draft AI Act. The report should rather describe what the impacts are, encourage self-reflection, and enhance transparency. Let me start with the content of Article 6. The article first requires a description of the purposes and operations of the system. Why does an authority use that system and how does it work? There will be a lot of technical information in this part of the report, but it should still be understandable to a reasonably informed member of the public. The next part is an assessment of the performance, effectiveness, and efficiency of the system. This provision aims to ensure that we don't just talk about risks. There are several advantages of such an assessment. It helps the implementing authority to self-reflect whether they spend their money wisely. It also informs the public about additional benefits that the system provides compared to current solutions. This might also increase acceptance. But assessing performance, effectiveness, and efficiency also allows critical external evaluation. Politicians or auditors can question whether this system was really worth spending taxpayers' money. Experts might make recommendations how the system can be improved. The next step of the report is to describe the impacts of the system. And we start with the impact on fundamental or other individual rights. From the perspective of public law, this is the most relevant impact of algorithmic decision-making by public authorities. It should be investigated thoroughly. What rights exactly are at stake depends on the type of system that is used and the context. Discrimination is obviously a very important issue, but we can easily imagine impacts on other fundamental rights as well. For instance, surveillance of public spaces might have a chilling effect on freedom of assembly. After that point, the report should describe the impacts on democracy, societal, and environmental well-being. Such impacts might not always be present, but will still be relevant in many scenarios. An impact on democracy can be imagined when voting procedures are affected, but also in more indirect ways if more and more decisions are taken out of the hand of democratically legitimized human decision makers. The environmental impact of algorithmic decision-making should also not be neglected. This concerns the energy consumption of such systems, but also the control of pollution by algorithmic decision-making. The damage if such systems fail could be enormous. The last impact to be assessed is on the administrative authority itself. Hopefully, with an increase in algorithmic governance, a lot less paper than shown in our picture will be necessary. But the introduction of algorithmic decision-making raises many other questions. For example, what training is necessary? The staff structure of the authority might also be affected. Will it be necessary to hire additional experts, or will the existing staff have less to do? This might mean that it can perform other tasks, but also that somebody will have to be made redundant. Now that the impacts have been determined, the next major step of the impact assessment is to assess the measures that the implementing authority has taken or will take to maximize the benefits of the system. After that, logically, the implementing authority must also describe the measures it has taken or plans to take to reduce the risks that it has previously identified. An important part of these measures will be some of the approaches that you all know from documents like the Draft AI Act or the high-level expert group's ethics guidelines. For instance, guarantees of transparency, data quality, or human oversight. After all this work, there are a few remaining tasks. The implementing authority must make a concluding determination of the risk level. This means reviewing the screening questionnaire that Jens Peter mentioned earlier and updating it by using the new information gained from the impact assessment. If the system is classified as high risk and not just low or substantial risk, expert and public participation will be necessary. Carolina and Katarzyna will talk about that in a few moments. Next, the report should contain an overall assessment of the necessity and proportionality of the use of the system. This also includes the question whether there are reasonable alternatives to the system which might be less intrusive. Finally, the report must contain a reasoned statement on the legality of the use of the system. So you can see that this is quite a long and detailed article. In addition, the drafting team created 2 annexes that contain even more detailed assessment lists to help the implementing authority with the structure. The annexes provide concrete questions to specify what the abstract legal terms in Article 6 might mean in practice. Annex 4A is a rather short and concise assessment list with 36 questions. Annex 4B adds a number of sub-questions to make even clearer what issues the implementing authority should or could investigate. With all this together, we really hope that the model rules provide a clear structure that helps the implementing authority to make a comprehensive assessment of its system. Here you can see the central parts of the article again. Now we are ready to leave Article 6 behind. The next step of the procedure will be expert and public participation. For that, I would like to hand over to my colleague Katarzyna.
Thank you very much, Jonathan. So what Jonathan has now presented was this part of the impact assessment process, which is common for all the systems having at least some non-negligible level of risk. But here we'll discuss the remaining steps of the impact assessment process, which are compulsory only when high-risk systems are concerned. In order to establish whether a given algorithmic decision-making system is a high risk or not, the implementing authority should first refer to the Annex 1, as Jens Peter said previously. Additionally, the recognition of a system as high risk can be a result of the impact assessment itself. So during the process, the authority may conclude that, in fact, its system seems to constitute a high risk. In such a case, some extra steps are required, namely, as has been said, expert audit and public participation. The logic behind it is quite simple. So high-risk systems require additional scrutiny before they are launched into the world and have a chance to make damages. At the same time, we want to avoid putting excessive burden on when systems pose relatively modest risks. So those extra steps combine the use of professional experience on one hand with a democratic instruments in which both those who are on one hand, again, knowledgeable about the inner workings of the systems and those who are potentially concerned by it can have their say. After the impact assessment report is produced, experts evaluate it against such criteria like its quality, accuracy, adequacy, completeness, and compliance with other model rules. Experts should mainly focus on checking the report and not the system itself, because the responsibility for the system and for the impact assessment should be on the implementing authority. And experts should act just as extra pair of eyes, I would say. However, in order to provide experts with all the information they may need, they should also be given access to the system, including the possibility to screen the code, to check, to test the system, etc. And results of the experts' work should be documented, of course, in a separate, we call it audit report, an opinion on the impact assessment report, if you will. There, they can voice their objections as to the shortcomings of the report, deficiencies in the systems, unaddressed risks, and so on. They can and they should include in that opinion, in that audit report, any recommendation, questions, statements to the implementing authority. The next step is, in the case of high-risk system, includes the collection of feedback from the public. And by the public, we mean individuals as well as NGOs and other civic society communities. There are two purposes of that. First is giving people a chance to provide the authority with their opinions, but also it can be a way of informing people that there is an algorithmic decision-making systems to be deployed in a way that it may concern those people. The model rules provide for a number of provisions to make sure that the public is given early and effective opportunity to acquire sufficient knowledge first about the system workings, participate in the consultations, and express their comments. For all those endeavors to bring tangible results, the implementing authority should be obliged to actually consider all those comments submitted first by the experts and then by the public. This step, we call it evaluation, serves exactly that purpose. The implementing authority must first take into account all the information and respond to them in the form of final justified opinion decision on the implementation of the system in question. All the results of the prolonged impact assessment process, including the impact assessment report, the Article 6 report, the expert audit report, the summary of the public participation process, and the final opinion should jointly be included in the so-called extended report. Now I will hand over to Carolina.
Thank you. Let me now introduce the content of the Article 13, the publication of the impact assessment report in the public domain. In order to ensure transparency of the process, the impact assessment report, and in case of high risk system, also the extended report, should be made publicly available by the implementing authority, at least online. The publication shall be available for the whole period when the system is used, and additionally 1 year after it is withdrawn from use. These key documents will be also included in the public register of the supervisory authority. Notice of the publication shall be given by the implementing authority to the experts, to members of the public who participated in the consultation, and the supervisory authority. In the event that these documents contain secrets as defined in our model rules in Article 8, the implementing authority shall publish a edited version of these documents that omit any secret information. Granting access to the unedited version of these documents is followed by general rules on freedom of information. The exception is here the supervisory authority, which always receive the unedited and the edited version of the report or the reports. The last element of our impact assessment procedure could be the repetition of the assessment. Using of the system and reviewing the system shall be monitored by the implementing authority. It concerns the case of these are factual indicators of substantial negative impact on aspects covered by Article 6 that were not envisaged in the report or the extended report. For example, the review of the system will be required if there are changes in the context in which the system is used or the personnel using it. Moreover, in our model rules, we have provided the obligation of reviewing the system and its impact after the system has been used for 6 months, where it has not been reviewed during the last 3 months, and also every 2 years after the last review, and amended the Article 6 report on the extended report. Reviewing is relevant in this regard because these systems are learning. So reviewing shall in particular reflect any additional knowledge gained during the practical use of the system. Such repeat impact assessments should be done in compliance with all the regulations applicable to the first impact assessment, including scoping, obligations to cooperate of implementing authority, system provider, data provider, transparency and protection of secrets, and expert audit, expert board, and public participation. The amendment report shall be published in the same manner as previously the impact assessment report. Now, I will give the floor back to Jean-Peter, who will present some of the special interest issues.
So you're still muted.
Okay, sorry. Thanks to Carolina. As indicated in the agenda, I will now turn to some issues which attracted special interest during discussions of a drafting team with the advisory committee, the membership consultative committee, or in webinars organized by the ELI. The first point has been mentioned earlier by Jonathan, i.e. the objective to provide an assessment which balances the societal interest in deploying innovative AI systems in public administration with the needs of effective risk management in order to increase the trust of people in such systems. In order to avoid misunderstanding, I need to stress that the impact assessment is not a licensing procedure, but a process of regulated and accountable self-reflection. And as mentioned by Jonathan, our model rules establish no new substantial or material standards for AI, but a structured impact assessment of already existing legal or non-legal requirements. Of course, such a structured assessment increases the practical relevance of these pre-existing substantive standards. Another new safeguard for pre-existing substantive standards, as well as for the new procedural requirements of our model rules, is the independent supervisory authority, which oversees the use of algorithmic systems by public authorities and guarantees the correct implementation of the assessment procedure. A fourth point concerns the relationship with EU law. Of course, the model rules could be adopted by the EU, at least for its own agencies. At the same time, the EU member states, non-EU countries, or even non-European states may implement adapted versions of the model rules. Especially important aspect of the relationship between the model rules and EU law concerns the proposed AI Act. We argue that our model rules complement the draft AI Act, which covers all AI systems offered and deployed in the EU single market, not only to or by public administration, but even more so by private parties. The draft AI Act, as proposed by the Commission, does not provide for case-specific, comprehensive, and participatory impact assessments. We argue that at least in case of public administration, such a safeguard for optimal increase of the public good by the use of AI or other algorithmic technologies, as well as for effective risk management, is needed. As mentioned, a first option to complement the AI Act would be EU law proactively prescribing impact assessment for public administration. The competence for such EU legislation certainly exists with regard to EU agencies and other EU administrative bodies using algorithmic decision-making systems. But much more questionable is an EU competence for obliging member states to introduce such an assessment for their own authorities. Consequently, the second option addresses autonomous national legislation on such impact assessments. In order to avoid conflicts with the market rules for AI provided in an EU AI Act, an opening clause should be added to the existing draft. Now, we are looking forward to the remarks of our other panelists, as well as to the questions and comments during the final plenary discussions. Thank you so much.
Thank you very much, Jens Peter, and all four of you for this very clear and well-structured presentation of the content. And indeed, as just mentioned by Jens Peter Schneider, we will now turn to the so-called external perspective. And first, we have the pleasure to have with us Jordanka Ivanova. She's a legal and policy officer in the European Commission, DG Connect, and she is in the unit responsible for AI policy development and coordination. As such, she's a member of the legal team who has drafted on the Commission proposal for the AI regulation, currently, as said, under negotiations. So in a way, I'm sure she will address also the issue of compatibility and complementary between the model rules and what is currently discussed and prepared by the EU Commission. I should say that she's not only a researcher, but also an attorney at law, and she advised companies, and probably this is also interesting for her external perspective, saying to what extent what is proposed is also interesting for these actors. So Jordanka Ivanova, you have the floor.
Thank you very much for having me here and listening to this very important work that the team has done. It's really impressive. And first, I want to start by congratulating you. Also, just to say that now I'm only a legal and policy officer. This is my previous CV when I've been advising and researching on companies as well. So just to clarify that now, I'll just try to give a bit of a perspective from the AI Act proposal. And of course, let me first start with the compatibility and the complementarity, which is indeed a key point. So I think this is actually a very important work that you're doing now, because it has, it's not just research, it has huge practical consequences, and it's highly relevant first for the AI Act, because now you have very much tried to align your proposal with the proposal of the Commission. But as you know, we are still in process of negotiation. So there are many changes that might occur during that time, and actually there is a strong request from civil society. Also, we expect now just the parliament of the lead committee in the parliament, which might place more responsibility on the users. So we are not yet sure whether we'll have some similar obligation in the end or not. And it's really important in any case what you are doing, because as you say, this is something that already many member states have been thinking. And I don't know if you know, but for example, Finland is considering to have a specific law, also Netherlands, where they had this huge scandal. So I think having this broader perspective and building on all this important work, because these are not the first proposals for algorithmic impact assessment for the public sector, but maybe a bit looking more in what has been proposed also in terms of access now at Algorithmic Watch, and trying to complement and build on this on the top of the AI Act proposal, the Altai 2, and also all these ongoing efforts would be really important, maybe to even further strengthen your analysis here and make it very useful in the end if we end up either in the Council of Europe or in the AI Act or even in specific member states to have such kind of impact assessments. So it was also very interesting to hear the complementarity. We think that indeed you go beyond the AI definition currently, although we are also not yet sure how it will be defined in the end. But in any case, looking at algorithmic decision making much more broadly will most likely be broader than the AI Act. And as you know, we even have in the GDPR automated decision making, which is probably very similar to what you have proposed. So we don't think there is a problem of having at national level such horizontal requirements that are not only AI specific, but in the end, if they can capture also AI, it's not excluded. And even now with the AI proposal, we specifically allow even for users of high-risk AI systems to go beyond the obligations in the AI Act. We have this Article 29.2. It's true that for other low-risk AI systems, we don't have such opening. So it might be relevant to consider how this aligns. In general, I think the issue whether EU has competence already in the AI Act to prescribe such assessment is really interesting. You are all lawyers here. I'm also one. I think it has been very interesting also the challenges that we have also heard from some member states, even in the council, and the legal opinions. Now, certainly the legal basis we have with 114 is sufficient even to impose obligations on users. Now, the issue is if we're going to really split it only for public authorities that are not horizontal, how it would affect. But maybe if they're horizontal, we don't see any problem just to add something more. Then we might need indeed to look for a specific legal basis, maybe more linking it to the data protection or something relevant if it is in the end legally considered it's not compatible. So it would be interesting a bit to investigate more this issue, because this would be certainly key. And then the other point I wanted to make is that it's really important to reflect a bit more, maybe also in your clauses, how this interacts with the data protection impact assessment that you already mentioned. Because I think one of the points is really important that we avoid also two separate assessments. There have been already attempts, for example, by the open loop and prototyping to combine and have one single assessment in the end, because it will be also for operators quite important to really make sure that they don't have two or overlapping obligations and we just build in addition. But I think your approach is, from the screening, the draft, it's really going in the right direction. The fact that you're also trying to address broader impacts is very interesting. This is something certainly missing in the GDPR as well. One key element maybe, and also the practical guidance that you give in the end, it's quite important, I think, because operators need a lot, and harmonizing this methodology, when would be actually substantial risk that requires this or not. I think with the GDPR, because I've been myself before working on this, I've seen how many uncertainty and different implementation and interpretations there are. So in general, it will be much more important to work on a clear methodology, maybe with matrix, and the fact that you also allow this prior consultation with the authority, I think is very relevant. So I think I don't want to take too much time. I have many other detailed comments, but I think in general, it's really going in a good direction. It will be interesting exactly a bit to look at comparable initiatives, because, you know, so now working on revising the contractual procurement clauses for public authorities with Amsterdam, work on public registers, and also other self-assessment tools that are taking place. So it will be just interesting also to try to look broader and have, I think it's really good that you explain and give a lot of rationale, but maybe a bit compare or build more on some things. And then, of course, I'm happy to remain available and discuss any other issues or provide more detailed comments on specific issues. Thank you.
Thank you very much, Jordanka Ivanova, for all these aspects, and also for raising many interesting questions. And I'm sure we will come back in the Q&A section, and Jens Peter Schneider or others will certainly answer some of your remarks. I have now the pleasure to give the floor to our last panelist, but not least, Mark Ruttenberg. He's founder of the Center of AI and Digital Policy, and he's also an adjunct professor at Georgetown Law or Georgetown University Law Center, depends how you pronounce it. And his expertise includes data protection, internet policy, open government, and AI policy. He has extensively published in these fields, and he has also served as an expert on many expert panels, including the OECD, UNESCO, or other UN panels. So to say that he's an expert would be a very little word compared to the expansion of his expertise. So I'm thrilled and really looking forward to what Mark has to say to us, and you have the floor.
Thank you so much, Pascal, and thank you to the ELI for the opportunity to speak with you. It really is an honor. And congratulations to all of those who worked on the model rules. This is a very impressive report, a very important contribution, and clearly will be influential in the development of the legal frameworks for the governance of AI. I wanted to say just a few words about my organization to place in context the comments I will make. I'm not sharing a screen today. I have a postcard to hold up, which maybe you can see with a QR code there. Ah, there it is. There's the QR code. So we have over the last couple of years undertaken extensive review of AI policies and practices now in 50 different countries. And in the course of our evaluation, we developed 12 metrics. Our metrics include such considerations as whether there's a meaningful opportunity for public participation, whether documents regarding a country's national AI strategies are publicly available, whether there's an independent review of the deployment of AI systems. We consider also a country's support for a resolution that was adopted by the Global Privacy Assembly, that's the network of data protection officials, in 2020 regarding AI and accountability. The main point I wanted to make at the outset is that in our evaluation of AI and democratic values, almost at the central meeting point of these various metrics is the need for an impact assessment, an assessment that's done by an agency set apart from the organization that intends to deploy the system, an assessment that is available to the public for review, an assessment that provides opportunity for public participation. So I can say to you that you are literally providing the key piece here for how we think about the governance of AI in a manner that is not only accountable, but also perhaps consistent, we would suggest, with democratic values. I appreciate it also in reviewing the report, not only the substantial recommendations and particularly the elements outlined in Article 6, but also the sources that you cite in support of your recommendation. The GDPR, of course, is an important foundation, both in Article 22 regarding a human decision maker, but also Article 35, which is the obligation to have a data protection impact assessment. And so your recommendation builds on the pre-existing obligation under the GDPR, and also structurally recognizing the competencies of the supervisory authorities established by the GDPR, and understanding how those authorities and tasks would be extended with regard to algorithmic decision making. I noted also the references to environmental impact assessments. We have actually in the United States litigated cases in US federal courts regarding the obligation of US federal agencies to undertake privacy impact assessments. And one of the points that we have made is that to fully appreciate the significance of an impact assessment, you have to understand that it's not a box checking exercise. If the conclusion of your review is that the project cannot be undertaken in a manner as required by the impact assessment, then the project is not undertaken. The simple analogy here in the environmental realm is if you propose to build a factory near a river and you don't have adequate methods to control the pollutants that the factory will produce, you don't manufacture the factory, you don't create the factory. And I think this is an important point to keep in mind as we think about the role of algorithmic impact assessments under the ELI model rules. There is going to be, as I'm sure many of you are aware, a blurry line in the risk assessment analysis between what might be considered high-risk applications and prohibited applications. So currently, for example, the EU AI Act will prohibit social scoring, but it will not prohibit remote biometric identification. But you see, this leaves open the critical question for those agencies that might propose to go forward with remote biometric identification. What will be the consequence of conducting the algorithmic impact assessment? And if the conclusion after this review is that the system cannot be aligned with fundamental rights, for example, then in fact what might have been viewed originally as a high-risk deployment is actually moved, at least as the proposal was presented, into the prohibited category. So these are important considerations. And I noted also your use of the Canadian algorithmic assessment tools, which I think are helpful as well. I'm simply going to point to a couple of other challenges ahead. Again, none of this is intended to diminish the significance of this very important contribution and the anticipated role it will play. By the way, not only in the context of the EU AI Act, but also, as you know, the Council of Europe is now underway with the development of a transversal legal instrument building on the legal elements report of the CAHI. This work is now going forward in the Committee on AI, which held its inaugural meeting last week. That legal instrument shares some similarities with the EU AI Act. I like to remind my students that one of the benefits of the Council of Europe Convention is that it is open to non-COE members for ratification. So there is the prospect that it could globalize many of the same norms that we might see in the EU AI Act. The impact assessment envisaged in the Council of Europe legal instrument is frankly a bit more narrow. It focuses on human rights, democracy, rule of law, the so-called Hudaria impact, but those issues are addressed in your Article 6. So in fact, your Article 6 impact assessment seems to fit quite well within the context of the Council of Europe proposed treaty. But here are a couple of challenges ahead, which I think are worth bearing in mind. Obviously, we've learned from the GDPR experience that having the resources and the competence to be able to make meaningful evaluation is not a small task, and frankly, it will be amplified in the AI world. One of our great concerns is that as government agencies move from rule-based expert systems, which are transparent and testable and subject to fairly straightforward revision, to machine learning systems, these are increasingly opaque, and it is difficult to replicate results. It is difficult to prove results. Vendors will likely say to agencies, we have all of this data that we can improve agency performance. But if you ask us to prove how we're able to do that, we're sorry, we can't, because that's the nature of machine learning. That is an enormous challenge ahead in algorithmic impact assessment. And I think we just need to understand that it is going to be, thrust upon public administrators who are trying to make these decisions and essentially told to trust a black box because of the reputation or the prior expertise of the vendor with whom they may be dealing. A related challenge, of course, will be claims regarding intellectual property. I think the model rules do attempt to address this and recognize some need to balance transparency opportunities for the supervisory authority and for the public, against the intellectual property claims of the companies that clearly invest a lot of time and money in the development of these systems and may be reluctant to share with a public agency or certainly with their competitors what it is that makes their system particularly effective. So we need to anticipate that. And I guess a final warning to consider, of course, is that some of the greatest challenges to government decision-making we know arise in the context of national security, threats of terrorism. This is where the governments feel most strongly about protecting the national security interest. It's also where the risk of abuse is greatest. For example, the use of nationality or religion as a proxy in a model for a likely risk factor based on some data model that says if this person is from this country, there is simply a somewhat higher percentage that they pose a risk on a terrorist index. We've had this experience in the United States. We've actually litigated these cases, and we know how those models are built based on religion and nationality. Someone who is subject to that decision-making would certainly want the ability to challenge an outcome where they have the belief that an imperfect and impermissible categorization was used, but that will also be the circumstance where the government's claim of national security and public safety will be the greatest. So it's another challenge to keep in mind. But overall, again, I just want to thank you for your contribution, for this important report, and for the role I suspect it will play in helping to promote AI systems that are aligned with democratic values.
Thank you very much to Mark Ruttenberg for these insightful comments also on the various challenges that are ahead of all those who will try to implement or will implement these model rules or some analogous provisions. The time is come now for the Q&R session. We have already a couple of questions, but of course, do not be shy, and you can ask your questions, and we will be happy to answer your questions as well as those that were posed by some panelists. So I will come back, of course, to those as well. But let me maybe just say that we have two questions already. So the first one about the PowerPoint presentation is a more technical aspect, but Jens-Peter Schneider just said that he agrees that these will be put at disposal. And so in our item news, and also on the web, then you will have access to that. And of course, this webinar is recorded and will be accessible. So also through the webinar, you will have the, so to say, the explanation going with the PowerPoint, because a PowerPoint does not often speaks for itself. It needs some explanation, of course. So that's for the first, of course, more technical questions. And then the second one, Vincent Rivolier asked whether we have also substantial rules proposed about algorithmic decision-making systems apart from these impact assessments approach and various steps that were presented. So I can just say that the European Law Institute has just approved an innovation paper on these algorithmic decision-making systems in more general perspective, and has, I mean, 12 principles have been prepared by Professor Teresa Rodriguez Heras de las Balel. I hope I pronounce her name correctly. She proposed 12 principles that were then discussed and adopted by the ELI membership, and will be, or is already published, or will be very soon published. And then we will also have a webinar on these more substantial issues, which is almost a second step. Once you have something, you need also to know how to deal with that with substantial rules. But this is not the object of our discussion today, so I will not expand, but there is something, and you can see it on the website of the European Law Institute. Now, getting back to more specific questions that were already addressed, maybe I can begin with one, which is the question of, and that might be my first question related to what Jordanka Ivanova said, and maybe I can ask that to Jens-Peter Schneider, because she mentioned the fact that low-risk systems might also be, let's say, interested, or some countries might be interested to expand the screening process and the more elaborate process of high-risk AI also to low-risk systems. So at least maybe that was not exactly the question or the remark, but that might be something. And my question linked to that would be, does it make sense? Or why did you make a difference between low-risk systems and high-risk systems? Of course, based on the Draft AI Act, I understand that, but why is the impact assessment different? And in that sense, of course, would you discourage implementing parties to expand that heavier system also to low-risk systems, or there is no risk to expand it to low-risk systems? Maybe Jens Peter.
Yeah, thank you so much. If I understand correctly, I would think first, it's not for us to decide how broad the scope of application should be. I think that's because there are so many trade-offs connected with this decision. So that's something for legislative organs to say. I would recommend to legislators to think about the resources on the side of public authorities, but also with regard to the public. If you have too many impact assessments with systems which are not really important, then you may discourage people to look at those sites and to really focus on those systems which are important. And I wrote my dissertation about environmental impact assessment, and the German abbreviation for this is UVP, UVP. And in German, we say unheimlich viel Papier, which means enormous amounts of paper. Yeah. And if you have too much paper, it's nothing for the public. And we have learned that also in Germany with regard to all the procedures concerning power lines itself. You can even discourage people with too many opportunities for participation. You need to be focused. And for that reason, I would think it's wise to have certain systems not be discussed if they are really not that relevant. But that's a political question to some extent. And of course, societies may be different in their eagerness to participate. So.
Or they may have much more resources, but it seems difficult to have more resources than German authorities, but I don't know. Linked to that, of course, many impact assessment of different kinds were mentioned. And when Jonathan Dollinger spoke about the content of the impact assessment provided for by the model rules, of course, you mentioned environment aspects, and that have been mentioned also by others. So I was wondering whether there might be a need for coordination between all these impact assessment, and whether the principles or the commentary provides for something, because we have this data protection impact assessment. We may have also environment impact assessment that may or may not trigger at the same time. And we may have even further impact assessment, as mentioned by Mark Ruttenberg, on as provided for by the Council of Europe. And sometimes they might be overlapping, sometimes they might be concurrent. So I wonder whether there is a need of coordination and how you provided for that. Maybe Jonathan might answer to that question.
Yes, of course. So we do indeed have Article 3 of the model rules, which says that the impact assessment must be coordinated with other procedures. It remains quite open because, as you say, there can be quite a lot of other procedures, and especially we do not yet know how the final procedures in the AI Act will look like. So we may have conformity assessment, we may have a risk management system, and it will be very interesting to see how this goes together. And for example, Jordanka also mentioned, or Mark mentioned that the data protection impact assessment is also in some respects similar. So a lot of coordination will be necessary. And I think Article 3 is a very important starting point for that. I also think it's obvious if something like these model rules or an algorithmic impact assessment is actually implemented, there will be a lot of work for lawyers to coordinate the specific impact assessment with each other. It's quite difficult to legislate for all of that. Personally, I think what might be realistic is to have the broad impact assessment provided in our model rules. And then, I don't know, you mark the environmental impacts in a different color, and you can then tell the environmental authority, this is the part that will be interesting to you. And then we have a color for the data protection impacts, which can be highlighted to the data protection authority. But that is just my imagination. I don't know what will happen in practice. But basically, Article 3 will be our starting point.
Thank you very much. Jens Peter, yes, please.
If I just may make at one perspective. As I already told you, I started my academic career with environmental impact assessments. And we introduced that instrument because we had various legal instruments for various called environmental media, we call for water, for air, and so on. And the idea behind that impact assessment was to have a combined view on all these impacts. And that's more or less the same approach we take here. Of course, privacy is important here, but our approach is much wider. And for that reason, I think we really need to take an overview about all these things. And of course, as Mark already also mentioned, we also need to take into account what are the objectives we want to pursue by introducing those instruments, and how can we maximize the benefits we can take from these new instruments, or to be realistic, if there is nothing to earn from that. But if we try to maximize the benefits, this is a totally different perspective than in a GDPR risk assessment. And that's fair. It's their job to focus on the risks and not on the benefits.
And this, if I understand correctly, this would be a so-called substantial coordination, but you still have the procedural coordination, at least in Switzerland where I sit. We have these two aspects in your environmental impact assessment. You have always to coordinate both the procedures because they are different, but they timely need some coordination also, and by authorities and so on, and then the substance. And so it might become very difficult and tricky. And I'm sure your Article 5 is a good starter, as Jonathan Dollinger said, but it's only a starter. So will you have a kind of a roadmap for authorities later on how to coordinate? Or do you think, for instance, the ELI should be a kind of partner for the authorities to try to figure out how to do things? If I may bring the ball back to you, Jens Peter.
That's a really complicated thing. Especially with procedures are quite often rather specific. And so if you want to coordinate the procedural side, you really need to take account of the details. And for that reason, we started with such sort of principle, because that's, I think, in the position of the ELI, the best way to approach this thing. Of course, if you are the European legislator, then you have the power to really coordinate on both sides, I would say. Yeah, but we can't make proposals for adopting the GDPR, for instance. Yeah, but if you're implementing such a thing, then you have also at your disposal the opportunity to make certain amendments to the GDPR in saying, for instance, in Article 35, this is needed or not needed. At the moment, Article 35 is not so specific to some extent with regard to the procedure. So there may be room for improvement. And then there should also be room for coordination, I would say.
Thank you very much. And of course, I was challenging you, but Article 3, I think, is central because it raises the awareness also of the authority of the need of coordination. And then, of course, it is up to them to find the right way and the more efficient, most efficient way, I think, too. We have an interesting question in the impact assessment. I'm not sure to whom I should ask the question, but we spoke about the so-called negative impact on fundamental rights, by the use of these ADS. But the question is also to what extent the positive states obligations need to be taken into account. And Vasil Kasanchin says, for example, considering the right to life, to take into account not only if the AI fiercely endangers this right, but also what positive active measures the state should undertake in order to ensure that the right to life is fully ensured. And the question is really, can that be taken into account in the impact assessment or not? I don't know whether Katarzyna, you are nodding, so probably you are ready to answer.
Yeah, I'm agreeing. So thank you. I'll gladly take the answer. So maybe the rest of the team will then supplement my answer. So we talk a lot about trade-offs today, and we talked a lot about trade-offs during our work on the model rules. So we can look at the impact assessment report, the Article 6 report, as a way to give to people an overview what this system is like, what the system's sort of pro and cons are, but also to give this overview to the implementing authority itself. And then having this whole broad picture of the system, the implementing authority has to decide whether to go or not to go with the implementation. So if we think about the impact assessment report and the whole sort of overview of the impact a given system may have, we ask the implementing authority to balance those pros and cons. So, for example, we don't only think about sort of stopping the negative impacts, but we may very well think about direct or indirect positive impact that the system may have. And this is also a part of the decision-making process on the side of the implementing authority before the implementation. Sort of, if there are risks, but there are also a lot of positive sides of using such a system, maybe it's worth implementing it after all. It's all about balancing. It's all about, as I said at the beginning, it's all about trade-offs.
Thank you very much. And that means also, of course, that it will not create these positive obligations on behalf of the state, but support the implementation in the balancing process that takes place under Article 6 assessment, impact assessment. Indeed. Yes, Carolina, you want to add something, please?
Yes, if I may, I'd like to return to the previous question connected with this coordination. I think that this suggestion about roadmap for public authority and also practical guide, which Jordanka Ivanova said also, it's very valuable advice for us, and we can think about that in the future. Maybe also the supervisory authority could be used in this process of coordination. Thank you.
Thank you very much. I'm sure all the reporters look forward already to go from one authority to the other to present all the details of the model rules. Let me maybe come to another point that was raised exactly by Carolina and also by Mark to some extent, I think. That's the issue about secrets. And the confidentiality of some elements. And Carolina, you said in the publication process, there would be some, of course, challenges, but also some emendation, deletion in order to protect the trade secret and other aspects. Now, I was wondering to what extent that aspect is also considered during the impact assessment procedure, because of course that's really at stake, and to what point the creator of these ADS may say, well, this is a really goes back to the root of our system, and if we give you all these information, then we will have no market anymore, or there's a serious problem of business secret or trade secret. And how is that taken into account in these assessment procedures put in place? Maybe Jens Peter Schneider, you want to answer that question, or maybe someone else? I'm not trying to put you in a difficult situation.
No, that's, I think, certainly something for either Katarzyna or Karolina, because the specific rules have been drafted by our Polish colleagues.
Perfect. So who wants to go first? Maybe Karolina, because you mentioned the trade secrets in the publication phase. So I was wondering, how do we deal with that in the initial phase?
I think that our obligation connected with protection of secrets refers to the whole procedure, and it's very important point, which was mentioned also by Mark Ruttenberg. These are a lot. We have a lot of money on the table. Let's set it's simple. So we try to regulate in a proper way in our Article 8, but I think it's very tricky point.
Okay, yes, Jordanka Ivanova wants to add something on that perspective, I suppose. Please.
Yes, indeed. No, I just want to say that this is a very important point, actually, and I think there should be a clarification also in your definitions, because actually trade secret, if you look at EU law, we have the Trade Secret Directive, and there everything that is know-how and business information is protected, and companies have the right to keep it secret if they want to keep it secret. So that's why we have also a lot of problems with data protection, for example, and many other areas, that even, for example, information about the accuracy of the system, how it performs, how it was designed, what is, for example, actually the data that has been used for the development, all this can be claimed that it is a trade secret. And I think there you have to a bit work more carefully, because if you just say every trade secrets are protected, I mean, where is then the balance with the transparency? So you have to find more appropriate, how to say, balancing how you should probably take into account in all cases certain type of information that should always be included in the public report, and that should be then also maybe always available for the public authority, not disclosed, but for the public authority to make its own assessment whether to use the system or not. And we have had also similar cases even in the US, where certain algorithms and systems are completely cannot be scrutinized by the court, because they are protected by intellectual property rights, including the source code. So there should be indeed a very careful elaboration how you try to balance more concretely these things, because I think now it's still quite open, and it can go in many different directions, how that article can be interpreted.
Thank you very much. Jens Peter Schneider, you wanted to add something on that point, I imagined.
Yeah, 2 points. First, with regard to the public participation, you may look at Article 11, paragraph 3, where we introduce this differentiation between the full report and the edited report. And the edited report is, so to say, as secret saving or preserving sort of report. And then I would like to draw your attention to Article 8, paragraph 2, where we at least have a starting point for some balance between the two sides of a coin. On one side, the secrets, and on the other side, the obligation to be transparent. And especially with regard, because we are talking here not about privately used AI, but publicly, by public authorities used AI. And the same holds true with regard to Article 7. We try to find balance to some extent. Maybe this is a starting point, but I think at least we learned that we need to have both values on the table.
And of course, trade secrets are not absolute rights. So it needs to be balanced. And of course, you need to have all the aspects taken into consideration. I still have further questions, but Katarzyna, you because that's an important point, so you are very welcome to
Just a very short, supplement to what has been said. I would also add that, as Jens Peter mentioned, Article 8, paragraph 2, that we sort of switched the default. The default is transparency, and only if you want to make something confidential, then you have to duly justify it. So sort of the focus is not, the emphasis is not on the protection of secrets, so to say, but on the transparency. And then if you want to keep something confidential, then you have to really explain why. And of course, and it's also another point is that the supervisory authority has access to the full report. So I think it's also helpful.
Thank you very much. And of course, this might vary from one country to the other if we speak from non-EU countries, for instance. Something that Mark mentioned struck me very, intensely, and this is the issue about replication. And because, of course, in an impact assessment, you assess certain processes. And if you have a machine learning algorithm, then suddenly you wonder whether the repetition of the same type of processes is even possible. And therefore, is it possible to have an impact assessment if there's no replication? Basically, that's how I understood at least what Mark Ruttenberg said. Maybe I'm exaggerating a little bit what he said, but it is really an issue. And so I was wondering to what extent the model rules may be still applicable despite the absence or the deficiency in the replication in order to assess the impact, or whether this comes at an earlier stage in order to define whether it's a high risk or low risk AI, because of course, if it's machine learning, it's probably high risk or even prohibited according to the actual draft AI Act. And therefore, the question might be more in the definition of the various categories rather than in the process of impact assessment. I don't know whether someone of you would like to answer that point raised by Mark that I thought might be interesting as a kind of almost last question of our panel this afternoon. Jonathan?
It's a very important question. And I think there are two layers here. The first is we have the screening procedure that Jens Peter mentioned at the start. And I think it's very obvious that, for example, if you have a system that uses advanced machine learning technologies, that might be a reason to increase the risk score. We didn't talk in great detail about that, but as we imagine the screening, it's a questionnaire where you have multiple choice questions, and if you tick certain boxes, then the risk level goes up and more stringent requirements will apply later on. And obviously it would be quite easy to say, do you use a system where the results are difficult to reproduce, and then the risk level goes up. The second is, how can we actually produce an impact assessment report? And there, to be honest, one of the issues with all those algorithmic impact assessments is we have many suggestions or proposals from a legal perspective, some more detailed, some less detailed, but we do not yet have quite a lot of methodologies done on the ground by technical experts. That is something that must be developed, and where we as lawyers can't say this will certainly be possible and or this won't be possible. But I think there are some interesting approaches. So for example, we have a report from the United States and our suggestions from the United States that say we could do something like benchmarking. So we could do, we could compare the output of the system with the output of human decision makers over a period of time. And then we could at least compare what the results are, even if we may not completely understand how the results come about. Otherwise, we as the drafting team can always say we only have to produce, we only want the implementing authority to produce the report. So if the implementing authority says, sorry, we couldn't assess that, we don't quite know how this comes about, and if the implementing authority absolutely wants to go ahead with it, it's fine with the model rules. They can simply say, we don't know. but of course, this might trigger other interventions because, for example, the data protection authority then says, sorry, this is not allowed under the GDPR or under the AI Act or whatever. So we can at least provide transparency in that regard.
I see, and it comes back to the coordination we were speaking before. I give the floor to Mark maybe, because he might also have insight from the US or from his experience how things might have been, handled in that situation. You're still muted, Mark.
Yes, so this is clearly one of the hard problems in the AI policy realm. And I will say, having participated in many drafting sessions, we are very resistant to the simple phrase explainability. It seems insufficient to talk about an explainability requirement. Not only do we talk about a transparency obligation, we try to add additional terms. So we talk about algorithms that are provable, scalable, robust, reproducible, and replicable. And these are all of the different elements that we think actually need to be demonstrated to have trustworthy AI. And if I may just propose a warning, on the vendor side, on the technology side, they will provide lots and lots of data to show that in other similar settings, the algorithm produced very good results. Let us show you all of this data. That becomes the justification from another setting in another use. And this is, in our view, not sufficient, and frankly at odds with the scientific method. I mean, we think about science as the ability to replicate results. And if we can't replicate results, we're a little bit, sideways from how we understand the scientific method.
Thank you very much. Jens Peter Schneider, maybe you may have the last word, so to say, before I close the session. And you have seen there's also a question regarding the issue of how to monitor privacy consideration. Maybe you can, I don't know whether you could address also that point right now or not. Or Carolina, okay, so how shall I do? First Jens Peter, or first Carolina on the question, and then I'll give the last word, so to say, to Jens Peter Schneider.
So very shortly about this question, I think that we would do this during our repetition procedure according to Article 14. Thank you.
That was a quick answer. So we will read Article 14. Jens Peter, please.
I try to be as quick as possible. I just learned from an American paper discussing a usage of AI for recommendation systems by online platforms. Yeah, and the colleague from the US says, we need to have their impact assessment as well, but we need to understand that we are just in the beginning of learning. It's not only machine learning, it's also regulatory learning. And so we need to have a starting point. And then I think that's the good thing about our impact assessment procedure. It's a procedure to enhance transparency and to have a basis for public debate. Yeah, and then the public, as well as the authorities, as well as the providers, have to learn, and they have to explain more or less. Yeah, and then the society, the authorities have to decide whether or not they want to take in these risks or they are more cautious. So I think the idea is to learn, and that's a good thing.
Thank you very much. And I'm sure we learned a lot today in this webinar. I think it's time to come to an end, because the time allocated to this webinar has already ended, and people might, well, they have probably eaten while listening to our presentations, which is perfectly fine. That's also the idea of these brown bag lunches, so to say. But it's probably time also for some of you to go back to work. So I just wanted to say first a word of thanks to first the reporters we had also in the attendees, the various reporters, the chair, Marek Wierzbowski, but also Marc Clément, and of course Jens Peter Schneider here, that worked a lot in these in the preparation of these model rules, and of course the whole team. And we had the pleasure to have several of the team members here in front of you, of us, this afternoon. And I must say it was really interesting to see how complicated the matter is, but at the same time you managed to bring in a concept of impact assessment that is both clear and makes sense to someone who reads it. And of course, as you mentioned several times, this is a starting point, not of the model rules as such, but the model rules are a starting point in order to discuss and to go further then also in assessing some different aspects and going further on some of the aspects we tackled today in the webinar. I'd like to thank very much Jordanka Ivanova and Mark Ruttenberg that took their time also to come in and to comment and come with astute insight of what could be still done, or what could be the effect of these model rules, and also how to coordinate some of these model rules with other impact assessments. And of course, we are all looking forward to see what the negotiations at EU level will bring as regard the AI Act, and to what extent these model rules will also be able to contribute to a better implementation, if I may say so, of the AI Act, or maybe also indirectly to the AI Act negotiation, because if you know that there's an impact assessment, you might be more open to have some of the AI in the high level risk AI rather than in the prohibited category of AI, because you know there's this assessment that might bring to some better understanding. So let me, as the president of the European Law Institute, say how happy the European Law Institute is, not only about these model rules and the work that has been done by the reporters and the panel and the team members, sorry, and all the bodies that work to give insight and understanding, but above all today by the discussion we had with these wonderful panelists. So thank you to all of you, dear panelists. Thank you to the public. And I wish you all already to celebrate a nice Easter time, despite the turmoil times we are going through. We are all thinking of people in difficulties throughout Europe, despite these celebrations that are coming. Thank you for being present. Thank you for your presentations. And I look forward to meeting you again in person or online. Thank you. Have a good day. Bye-bye.